Okay, so what rights, if any, do victims of crime have when it comes to prosecutions? What's brought this on? Two stories really. First of all, you may have seen that Nigel Farage is rather put out at the level of sentencing on the person who threw whatever it was at them. And there's also another story that, no disrespect to Nigel, I think is perhaps more important, where a woman made an allegation of a very serious, sexual assault, to get round the algorithm, but the worst kind of sexual assault. However, the defendant suggested that maybe she had an issue with sleepwalking, and she had actually, the act had taken place when she was sleepwalking, and therefore how was he to know that she wasn't consenting? And the CPS didn't just drop the case, they offered no evidence, which meant it was a formal not guilty verdict. So that was the end of the matter. They have, however, now apologised. But, what rights are there? Well, theoretically, we have victims commissioners and things like that now who are supposed to look after victims' rights. But is there anything practical? Well, there is a sort of victims review scheme that the CPS operate. And that is where somebody is a victim of crime, and that's whether they're a direct victim themselves, although it can also, for certain offences, obviously it can include, the victim's family. It can also include actually businesses, because it covers any type of harm, sort of physical, psychological and financial. If the CPS take a view where they either do not prosecute, they discontinue a prosecution, they ask for a case to be left on file, that is, it's not to be proceeded with, but it isn't actually formally dismissed, or they offer no evidence, which is a formal dismissal, then the person aggrieved can ask for a review of that decision. Now, if the decision means that the case could theoretically be resurrected, then, that is one possibility. If, however, say it's a case where, in that particular serious case, where the CPS said, we formally offer no evidence, and the court records a not guilty verdict, well, because of the rules on double jeopardy, that's the end of it. We call it atrefroid acquit. You can also be atrefroid convict. If you've been convicted of an offence previously, then you can't be generally re-prosecuted for it. A couple of exceptions there. First of all, with very serious offending, if new evidence comes to light that was not available at the time of the original proceedings, whether that's because it just didn't exist, or with reasonable due diligence you couldn't have found it, or say, for instance, the culprit was concealing that evidence, that can get you around it. Also, if somebody, say, for instance, is convicted of assault, but the victim subsequently dies, then they can actually up the charge and retry on a murder conviction. But that's generally the only two exceptions to, the double jeopardy rule. But what rights do you have? Well, if you are aggrieved, and we'll just do some of the terminology here. We talk about victims, complainants, suspects and defendants. If somebody makes an allegation of a crime, but one of the issues is, was a crime even committed? So say, for instance, in, SUL cases, if they say, well, actually, we're notwithstanding what happened, you'd also have to prove that somebody wasn't consenting. Therefore, there is, the actual, was there a crime even committed? Is an issue. In that case, somebody's called a complainant. But let's say there's no issue as to a crime was committed. Somebody, is dragged into the bushes while out walking, or somebody is violently assaulted. But the issue is, who was the person who did it? Well, then they will describe the person as the victim, because it's not in dispute that a crime was committed. The argument just is whether or not they've actually got the right person. And that's when we talk about suspects and defendants. If somebody's saying, not me, Gov, I wasn't even there, then you're just you're just a suspect. If, however, you say, well, yes, I was there, these things happened, however, I do have a defence, then you are a defendant. I mean, generally speaking, all suspects are defendants, but not all defendants are suspects. But that's just sort of technical terminology. So you can raise this, and you say to the CPS, I want you to reconsider the decision. The only right you have is that somebody actually does review the decision. There's no right to actually, them to change their minds. It just means somebody takes a second look at it. And they're also supposed to give you, an explanation as to why they did this. They're also supposed to consult, before offering, like, I know we don't officially have plea deals in this country, but sort of we do. So if they were, for instance, going to offer a lower charge that somebody's willing to plead guilty to, then they are supposed to at least consult the victim or their families. But again, they don't have the final say. The only right is to be listened to. It's not to have anybody act on that. But yeah, it does cause problems, like I say, if it's been, an issue where a not guilty has been recorded, you're fairly stuffed. What are your other options? Well, you could, if proceedings were still possible to, bring back to life, you could bring a private prosecution. A lot of people have done that, where the CPS have, declined to prosecute, and they brought private prosecutions and they've been successful. However, the Director of Public Prosecutions does have a right to take over any private prosecution, and they can either continue that or they can discontinue it. I mean, and you can judicial review those decisions, but of course it becomes very expensive very quickly. But what about Mr. Farage? Well, actually he wouldn't fall within the scheme, because the issue there wasn't that they didn't prosecute, it's that they prosecuted just for Section 4 Public Order Act, which is, putting somebody in apprehension of the immediate use of force. Now, not getting into the sort of two-tier justice thing, arguably there were more serious charges that could have been brought. But that is something that is out with the scheme. What charges people are brought, are proceeded against, it doesn't fall within the scheme. I mean, can you appeal these sorts of things? Obviously, if somebody is convicted of an offence, whether in the Magistrates' Court or the Crown Court, they do have certain rights of appeal. You've got an automatic right of appeal from a conviction in the Magistrates' Court. That just goes to the Crown Court, though, where it's one Crown Court judge and 2 lay justices. If you're convicted in the Crown Court, then you can try your luck in the Court of Appeal. But what's the other way around? What if the prosecution want to appeal? Can they? Well, if it's a acquittal in a Crown Court trial, generally speaking, no, they can't, unless there has been evidence of, say, jury tampering or something like that. They can go off and they can go to the court and say, we think the judge gave the wrong direction, so just for future reference, can you rule on this? Although the Court of Appeal tends not to like to rule on hypotheticals. They say, no, bring it, as a real case that would have a real outcome. We're not just there to sort of, write the law books. That's slightly different in the Magistrates' Court. If the magistrates direct themselves incorrectly on the law, then the prosecution can appeal by what we call way of case stated. So they say, well, the magistrates just got the law wrong. They applied the wrong test. In that particular case, that goes off actually to the administrative court, because it's a technical legal issue. And the administrative court can either say, we dismiss the appeal. They can theoretically say, actually, yeah, the magistrates did get it wrong, and on the agreed facts, there should have been a conviction, so we just impose a conviction. What they usually do, though, is say, okay, well, we're not here to argue about the facts because they were in dispute, but we say, go back to the Magistrates' Court for a retrial. Usually they'll say it with a different bench, but now applying what we have said on the law. Similarly with sentences, if a sentence is unduly lenient, and this is only indictable offences, Crown Court stuff, if it's believed that a sentence is unduly lenient, then the Attorney General can apply to the Court of Appeal and say, I think the trial judge got this wrong. Didn't sentence in accordance with the sentencing guidelines or something like that. But the test is unduly lenient, not just that it was a little bit lenient. So, if somebody, you were lucky there, another judge or most of the judges might give you a bit more for that, but it's still just about within the sentencing guidelines and it's still just about justifiable, then in that particular case, they won't interfere. But yeah, these are all the sorts of issues. So like I say, to summarise, yes, crime victims have some nominal rights, but it's pretty much just a right to be heard. It's not, because the thing we need to remember about the criminal justice system is, in a criminal trial, the victim, they're not a party to the trial. They're effectively just a witness. The case is between the Crown, the state, and the defendant, because the idea of criminal proceedings is society has a vested interest in just, detecting and punishing crime generally. They're not actually looking out for any particular individual. Now, that's obviously different if people bring civil proceedings, and that quite often happens. You could do that. Somebody could be convicted of a criminal offence, and even acquitted of a criminal offence, but the victim could bring a civil claim because most crimes are also torts, civil wrongs. Assault is a civil wrong, harassment is a civil wrong. The M word is a civil wrong, so the families can bring proceedings there. But so's financial crime. There are lots of financial crimes that are civil equivalents. Conversion, interference with goods, all that sort of thing. And in a civil case, then the claimant is actually a party to the case, and also in a civil case, then the test is it's the civil thing, which is balance. It's more likely than not. That's the civil standard. Is it more likely than not that this person actually is liable? I mean, sometimes they'll put that in terms of 51%, 49%. Courts generally don't like that. They just call it the balance of probabilities. On the balance of probabilities, is it more likely or not that this person did or did not act? Whereas, of course, the criminal standard is, well, you're all shouting it out there, and you're all going beyond reasonable, and you're wrong, because that's only in America and films. The criminal standard here is so that you are sure. Although judges will usually then say something like, you may have heard of beyond reasonable doubt, it's the same thing. I mean, and that's all they do. They never qualify that. There were attempts where they'd say, what does sure mean? Well, it's an important decision. Would you actually buy a house? How sure would you have to be that house didn't have subsidence or asbestos problems? And the Court of Appeal said, no, just leave it. Sure is an ordinary English word. Are you sure that happened? Are you sure about that? Well, it's very hard to sort of quantify that. It's just you're either sure or you're not. But yeah, that is your other option. I mean, it is open to Mr. Farage. If he wanted to, he could bring civil proceedings against the thrower. And actually, one thing in civil proceedings is that the fact that somebody has been convicted of an offence is admissible evidence that they actually did the thing that they're doing. It's not automatic. You can still, in a civil case, say, I don't care that I was convicted. I still say I didn't do it. Although, obviously, if somebody pleaded guilty, then that's an admission, and it's very hard to resile from that. Although, again, there is a procedure in civil proceedings to withdraw from admissions. Usually it's not something as serious, not something as clear-cut as that. It'll be a lot of time in commercial things. People will say, well, we accept actually you were entitled to that money or that you got that wrong. And then they'll go, oh, actually, no, we've just reviewed our own procedures, and that's not true. Please, can we withdraw the admission? I mean, courts are very reluctant to let people to draw admissions because it's like, well, be more careful about what you say. But yeah, it can all get a little bit complex. But there you go. I thought, as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm at a place called Old Key, Key, which is an old abandoned village. Used to be quite a sort of prosperous, thriving community, hence the huge church behind me, which is only the tower left now. But when the sort of financial situation down here changed, they literally just upped sticks and moved the entire village about 3 miles away. And rather than call the new village New Quay, which would have confused it with New Quay, Quay, they just call that village Quay, again, Kea, and this place became known as Old Key. And you'll notice I am sat down because I'm still gasping for breath. I'm just living off cough drops and cough medicine at the moment. So thank you for all your lovely, sympathetic comments, and I hope I'm not quite as wheezy today.